Hello, everyone. Nick Chavez here, along with my law partner, Martin Valko with Chavez and Valko, your key to immigration solutions. And you all know, right? They announced a new process for individuals who are married to U.S. citizens that would give them some form of temporary protection here, and more importantly, would create a pathway to apply for their green cards without having to go through the waivers and having to leave outside the country and risk denial and all that. But before we begin, I just want to say, folks, don't forget to hit like and subscribe to our channel if you want to receive information, if you want to watch the latest shows. This issue is going to be developing, I'm sure, and so it's important to stay on top of it. So basically, great news for those who want to stay here in the United States during this immigration process, as I mentioned, instead of having to leave the country and apply for waivers and all that mess. And this benefit is called Parole in Place, or PIP, or some other word, because I'm seeing some other descriptions too. But the legal term for it is Parole in Place, so we'll stick with that for now. And since the announcement, there have been some developments. USCIS has now posted more information since the announcement on Tuesday. And you can find this information right at uscis.gov. We'll also be posting that on our website. But these are the frequently asked questions. Frequently asked questions, I mean, this just started, but there's questions and answers, right? They posted these questions and answers that provide some information beyond the announcement that was made on Tuesday, and you can find those there. So we're going to go through those and just provide some insight based on our experiences as we wait for the regulations, which the announcement could be made any time. It could be made tonight. It could be made tomorrow. It could be made over the weekend, next week, the following week. So we're waiting for those announcements because they will provide us more information about the filing process and when will USCIS start accepting these applications. So that's really what we're looking at. And so, how are you doing, Martin?
Doing well. It's we've been consulting with prospective clients and current client over the last couple of days since the announcement, and it's a positive development. We're all cautiously optimistic that it is going to get enacted, and hopefully within a couple of months we'll have a date to file. But as you mentioned, Nick, no, don't get fooled. There's nothing to file yet. There's no fees to be paid. There's lots of, I guess, scammers out there and people that pretend to be able to assist you with this. So, the information is going to be posted on the USCIS's website, and then we'll be providing you with these details. So, but it's people are excited. They've heard about it on media and from other sources, from their family members, and everybody has questions, and so that's why it's important to sit down and consult with immigration attorneys who have the experience dealing with similar types of cases, and they are able to look not just at the parole in place, but potentially identified eligibility for some other relief or benefit.
Yeah, you mentioned scams, right? So USCIS did post that information on its website about being careful because there is no filing process yet. And so there's no form. And if someone is telling you, hey, come on, let's fill out the form, let's file it, immigration, and we're telling you guys, no, you guys got to stop, you guys got to wait. But there are some things you can start doing, and we'll talk about that. I want to just cover real quickly on their Q&A. They talk about the very basic concepts or the basic elements to apply for a parole. Be present in the United States. We know that without admission. So this is going to apply for those who entered without inspection and have been here continuously present in the United States for at least 10 years as of the date of the announcement, which was June 17th, 2024. have a legally valid marriage to a U.S. citizen. Boy, are we seeing some issues there, right? As of June 17th, 2024, we saw a bunch of people flock to the courthouses to try to get married. So that's going to be an issue, but that's one of the main requirements. And of course, you have the more broader requirements. These are the ones that we're kind of waiting for more information. You know, you must not have a disqualifying criminal history, or they say you must not be a threat to national security, right? To public safety, and then your other loosey-goosey broad standards that they have. You also have to show that you deserve it as a matter of discretion. Well, okay, so those are the elements aside. The questions that they have here is, when will the process start? And as we mentioned, as Martin mentioned, not yet, very simply, but this is something you have to look at every single day, right, Martin?
Yeah, no, it's just got to be careful. Just got to listen to us or other people, media, and as soon as that date is published, then we'll know more. When you go back to deferred action for childhood arrivals, or DACA for short, the executive action was announced on June 15th of 2012, and it was enacted on August 15th, so 2 months later.
Yeah.
So essentially, something similar will be happening here as well. Maybe it will be in 60 days. There was some chatter that it may get promulgated and made into a rule through the notice and comment period. That could add some more time on the timeline. So we'll wait patiently.
Well, yeah, and that's a good point there, right? Because there's an announcement, and immigration agencies, sometimes they make announcements and they're effective the next day. Those are policies. You know, what size of a color photo should you include with your application, or you know, are they going to include fingerprint appointments? Those kind of things. You know, immigration could act immediately. But this is kind of in the larger scale, this is a big thing, right? So it involves an announcement, like we just heard, and then the next thing is rulemaking, where they will publish this. When they say Federal Register, that means they're going to publish these as regulations. And why are they going through the trouble? Because DACA initially did not go through this process, and that's why it was attacked. So they're trying to shield themselves from attack by publishing these regulations, make it more tougher for litigants. And we're anticipating some litigation from saying, hey, you guys are not doing this correctly. You know, you're just making it up. But regulations give that effect of a law making orderly process. So what will be, actually, I kind of mixed them up a little bit here. What will be the duration of the parole? What happens when it ends?
Well, so what's been announced is that the parole will be granted for a period of 3 years. And during that time, presuming that the person is admissible to apply for permanent residence, to apply for the green card, then they will have to do it during this 3-year period. So as of it is right now, the parole should be granted for 3 years from approval. And so once you are granted parole, you should immediately be eligible to apply for work permit, employment authorization application. That will take its time as well. And once you have that, then persons will be able to apply for typically for Social Security number and driver's license. And then it just depends if they are eligible to jump in and be able to apply for adjustment, then they can go through that process.
Yeah, we've been getting that question already, you know, because that's a good point. The application for parole is in and of itself a benefit. It's supposed to prevent someone from being deported, the shield, right? And then the candy, the sword, if you will, is the application for work authorization. This is actually what people are really, really wanting. And they're two separate things. So you get parole, and then if it's approved, then they will allow you to apply for a work permit. And so some people have been asking, can we file them at the same time? And it does. We'll know soon with the regulations, but reading the questions and answers that were posted by immigration, it suggests that they're going to have to wait until the application for parole is approved. I mixed the order of the questions here, but I'll just go ahead and address this super quick. And it has to do with what happens. This is very simple. What happens if you apply prior to the start date? So this goes again with hold off, hold, do not send anything just yet until immigration gives us the green light, and set the date. If you file something before, and a lot of people are really antsy and anxious to do it because they saw what happened to DACA when it was enjoined, when it was blocked partially by a Texas federal judge. And so if you do make that application, I understand your concern, but if you make that application prior to the effective date, they're going to reject it. That's what they said. All right. This is a good point right here that I think immigration, I'm glad they said this. What can we do now? What can they start doing now?
Well, I mean, yeah, I mean, it's you know, that main element is proving physical presence for the last 10 years. So June 17th of 2014 until the application process, until you file the applications, you're going to have to show that you've been physically present in the U.S. So that's the homework that you would be, or the person, the applicant would be doing, assuming that they were married on that date, whether it was a legal marriage prior to that, or it is a common law marriage that could be registered that predates that date, presuming that they met the requirements of, we're in Texas, and Texas is a common law state. So it's that homework that everybody should start doing. If there are any infractions in the past, immigration detentions, kickbacks at the border, convictions, those are things that one should be looking at and start collecting that information. So an experienced attorney should be able to review it and then provide with more guidance.
Yeah. What I tell my clients is, like, gather anything with your name on it and a date, and you just gather that, and it has a year. Try to collect 1 or 2 items per year, and then just go ahead and give it to your attorney and have them sift through it and see which ones are they going to present. So that's the rule of thumb for my clients. Let's see here. We go ahead and well, I need to submit my biometrics. So biometrics, what that means is that when you apply for an immigration benefit, USCIS wants to know more about you. And so they'll take your fingerprints, and they'll take your photos, and they'll enter that information. But the quick answer to that is yes, right?
Mm-hmm.
They're going to need to do that. Will the parole application be available online or on paper? And I think that they're saying real quickly, it says further filing instructions will be available in the near term. I will say that online filing is available. It's kind of hit or miss. We've done a few, most of our clients, because it's a new thing with immigration and it's somewhat clunky. I mean, that's been our experience, not only our experience, but it's been the experience of other people. It might be, hopefully, by then it'll be more efficient. They'll work out the kinks, but we'll need to wait to see what happens if they'll allow us to do that. Can the filing fee, what is the, well, there's a question about the fee, and I just jumped the gun here. We don't know what the fee is. And so if we don't know what the fee is, we don't know if they will be able to waive it. For some applications, you're able to get a fee waiver, meaning because your income level, because you don't, your situation, your economic situation, the government will allow you to either waive the fee or just let you pay part of it. So we don't know yet. Martin, this was a question that was posted as well. If you came in the United States lawfully, are you eligible for parole in place?
No, you're not, and that was one of the requirements, that you were not admitted or paroled into the U.S. To apply for parole. So, not for this particular one, or any other parole that I'm aware of. So not at that point, because if you are married to a U.S. citizen and you were paroled or lawfully admitted, you don't have to wait for the PIP. In fact, I spoke with somebody today that they did have a legal entry and they heard about the announcement. It's like, hey guys, we don't have to wait for anything. We can go through the adjustment right now. So yeah,
You're
they
right.
they would not be eligible.
That's correct. Yeah, they would be eligible for the green card directly. How about if you're in removal proceedings? I mean, there we have several people, I'm sure, that are in removal proceedings. They have a court date with the judge. This could
Yeah.
potentially apply to them. What's going to go
Well,
on with
apparently,
that?
well, according to the information that it's out there right now, it would, if they have ongoing current removal proceedings, and so they should be, again, according to the information that is available by USCIS at this moment, and it would be USCIS who would, the Immigration Service, who would adjudicate it. And so when person is in removal proceedings, it's being handled by Immigration and Customs Enforcement, and the government prosecutors, the chief counsel's office. And so in the past, when DACA was introduced, people in removal proceedings had to go through ICE. And so, that would have been the assumption here. But so far, the currently available information says that it would be USCIS if those removal proceedings are ongoing.
Yeah, you got two different agencies, really. Well, you got three. You got USCIS, who might just give you this parole in place, but then you are in the jurisdiction of the court. What would the court judge? What would the immigration judge do? And then you have the prosecutors. Their office. They're the Office of Chief Counsel, but they're the DHS attorneys, and they work with DHS, and they have their own guidelines. And I imagine, that they're all going to get together and see, okay, if we have this situation, what are we going to do? I think for your enforcement priority cases, I think obviously they're not going to be given parole in place,
Right.
people who committed felonies, etc. But your abuelitas, your people who don't present a threat to society, they might be allowed to not only get parole in place, but the judge might say, hey, you know what, we'll go ahead and terminate proceedings here. Well, we'll see.
Yeah.
All right. If my parole request is pending and you have an encounter with CBP, what happens? Besides having our app.
Besides having Law Pilot, these are considered case by case basis, on case by case basis, and so typically a pending parole application or grant of parole should protect you. I mean, you shouldn't be put in place in removal proceedings, but there's going to be some further clarification on that.
Yeah, and
that's the red button that you hit when you are experiencing some troubles.
This is precisely why we made this app.
Exactly.
All right, very good. The next question that I have here is, if USCIS denies my application, what's going to happen? What's going to happen? Are they going to be placed in removal proceedings?
It's to be seen, right? I mean, it just depends on what threat level do you are you threat to public safety, national security? It really, again, this will be a case by case decision decided by the officers. We'll see.
Yeah, if you have an extensive criminal record, and if you could be considered an enforcement priority, someone that immigration wants to place in proceedings, then it'd be a good idea to speak with a lawyer. And I would usually, if they are an enforcement priority, I'm not looking really to request a work permit or parole or anything like that. But it's case by case, like Martin said. It just depends on the factors. And
It's the type of, for example, if we're talking about with criminal record, it's the type of conviction, right? Were you 20 years ago arrested for a theft under $50 at a Walmart
right,
versus, were you convicted of cocaine or controlled substance trafficking? You've been ordered deported, and you are still in the U.S. because you did not depart. Yeah, in the latter example, you should not be applying for parole in place. So it is
right,
so important. We can't stress it enough. A lot of times you have various online services and do it here. It's very inexpensive, and what it that type of service, that kind of process is missing. Is just that review, that analysis, that advice, right? Hey, if I were you, if this was my mother or if this was my family, this should not be filed. So
yeah.
definitely.
Yeah, and then it goes with the next question, the same thing. And we will obviously need to wait until they give us more guidelines. The regulations may shed some more light on whether a person who has a certain criminal background should apply for a parole in place. Maybe they'll define the types of crimes that
Mhm.
would disqualify you, just like what they did with DACA,
DACA,
right?
yeah.
Listing those. So it'll be interesting to see if they do the same thing. Um, Here's a question about children. Can the undocumented child of a non-citizen spouse be covered by this policy and apply for parole?
Yeah, they could. And so again, it's just the analysis, whether under the Immigration and Nationality Act that child is considered to be a stepchild of that U.S. citizen sponsoring spouse. And so as long as they were married before that child turned 18, which established a step-parent relationship, and again, that child, just like the parent, the immigrant parent, was not admitted or paroled into the U.S., they should be considered for the grant of parole along with the immigrant parent.
Yeah. In general, right, the definition of a child for immigration purposes is number one, you have to be
Under
under the
21.
age of 21, and number two, be unmarried. And then there's an extra requirement for those who have step relationships and step children who want to apply through a step parent or be included in an immigration benefit such as this one. They have to show, and to meet the requirement, the stepchild, they have to show that step relationship, as you said, Martin, it has to form prior to their 18th birthday. So biological parent needs to get married with the step parent prior to the child's 18th birthday for
Mhm.
them to qualify. Okay, very good. And then they go on to discussing really quickly about employment authorization. I think we touched on this,
Yeah.
and they file at the same time. We don't. Well. Look. The answer they give us here on their website is like an individual who is granted parole is immediately eligible to apply for an EAD. EAD means employment authorization document, work permit. And so that indicates to me that they have to first request parole, and once they're granted, then they could apply for employment authorization through that form they mentioned there too, the Form I-765.
Yeah.
All right. And then there's another question here. The last question they have is, how long will it take to receive a decision? And that's a great question, but and who knows? We don't know yet.
A few to several months. So that's been our experience, unfortunately, because that's, in certain instances, your parole could last for a year or
Right.
deferred action for 2 years. And when you then have to apply for work authorization and you have to wait, let's just say 5 months or 6 months or 7 months, then you only have the work authorization for the remainder of the relief that you were granted. So with the push to online filings, our hope is, and always has been, and is now more so, that it will be almost automatic. That somebody's going to, maybe USCIS AI will take over and analyze and see approved, boom, done. Maybe it should be incident to the parole, right? Incident to status, like you have in spouses of investors and intracompany transferees, the work dependents of spouses of workers or investors, which for a long time you got the status as a dependent, and then you have to do this. You had to apply for the EAD, and it took months and months and months. Now they made it, after some litigation, incident to status. So the minute you were considered to be dependent, you can go out there and be work authorized.
Well, folks, that's it for today. We just wanted to go over these FAQs with you and add some of our insight based on our experiences. Thank you, Martin, for sharing your wisdom. I hope everyone has found it useful, and please remember to hit subscribe and like this video to receive the latest news on this topic and other immigration news. Thank you, everyone.
Thank you.